May it please you, my lady, the Chief Justice, my ladies and my lords, my name is Nelson Harvey. I appear for the first to fifth respondents in all the appeals and the applications. These are Dr. David Ndi, 𝙏𝙤𝙧 𝗏𝙤𝙧, James Gondi, Wanjiru Gikonyo, and 𝙏𝙗𝙗𝙧. Thank you.
May it please the court, I appear with Ms. Muthoni Nyuguto for the 11th.
Your name, please?
My name is Martha Karua, appearing with Muthoni.
It's for record purposes. You need to record.
I'm leading Muthoni Nyuguto for the 11th, 12th, and 13th respondents in the Attorney General's appeal, that is petition number 18 of 2021. And like my learned senior George Oraro, although the directions are for one counsel, it's difficult for those of us who are leading to come without the advocate on record.
Okay. Thank you.
The Honorable Chief Justice, my lords and ladies, my name is Elias Mutuma. I appear for the 7th, 8th, and 9th respondents in the Attorney General's petition, alongside Ms. Caroline Gerono and Professor Kidore Kindeki, who is appearing online. Thank you.
Put on your mic, please, so that we can record.
Honorable the Chief Justice, the Deputy Chief Justice, and judges of the Supreme Court, my name is Gilbert Nyamweya. I appear alongside Morara Omoke and Lesingo Topua. We appear for the appellant in petition number 11, that is Morara Omoke, who is also the 13th respondent in the Attorney General's petition, and he is the 76th respondent in the petition by IEBC. Thank you.
Yes, may it please you, Lady Chief Justice, my lords, my ladies. I appear, my name is Paul Mwangi, I appear with Mr. Jackson Awele in petition number 11, Morara Omoke, for the 4th respondent, for the 2nd respondent and 4th respondent. In petition number 16, Attorney General's appeal, we appear for the 20th and 23rd respondents. And in petition number 18 of IEBC, we appear for the 17th and the 77th respondent. Thank you.
My Lady, the Chief Justice, my name is 𝙏𝙗𝙗𝙧 𝗏𝙗𝙗𝙧. I'm privileged to appear before you one more time, this time for Dr. Jack Mwimali, the 14th respondent in the IEBC appeal, and he's number 74 in Omoke's appeal. I hold brief too for Ms. Kituku, who appears for Muhuri, the 78th respondent in Omoke's appeal, and respondent number 82 in the IEBC appeal. Both of my clients are omitted from the AG's appeal. Thank you.
The Honorable Chief Justice, my ladies and my lords, my name is Wambulwa. I do appear for the Speaker of the Senate and the Senate, who are the 15th and 17th respondents in the Attorney General's petition, and 17th and 18th respondents in Morara Omoke's petition, and 8th respondent in the IEBC petition. I also hold brief for Mr. Quioni Josephat for the National Assembly and the Speaker of the National Assembly, who are 14th and 16th respondents in the Attorney General's petition, 19th and 20th respondents in Mr. Morara Omoke's petition, and 7th respondent in the IEBC petition. Thank you.
Good morning, Your Ladyship, the Chief Justice, honorable judges. My name is 𝙏𝙗𝙖𝙠 𝙔𝙤𝙪. I appear alongside Mr. Elisha Ongoya. We are on record for Justice Juma and Isaac Ogola. These two respondents appear at number 11 and number 12 of petition E16 of 2021. Thank you.
Good morning, Your Honors. My name is Isaac Alwochir, the 70th respondent in Morara Omoke's petition of appeal, 21st respondent in the Attorney General's appeal, and the 78th respondent in the IEBC appeal. Thank you.
With your kind permission, the Honorable Chief Justice, I'm Mr. Steve Ogola, here to pick a ruling on behalf of the proposed interested party, the Party of National Unity, in the AG's petition of appeal.
A very good morning, the Honorable Chief Justice, my lords, my ladies. My name is Odongo Brian, here to take a ruling for the proposed Amici, Professor Rosalind Dixon, Professor David Landau, and 𝙏𝙗𝙖𝙑 𝙔𝙤𝙪. Most obliged.
May it please you, my ladies, my lords. My name is Orlando Lembo. I appear together with Ms. Sally Omoto, for Professor Charles Fombard and Dr. Adam Keabebe, who have proposed Amici. And I also hold brief for Professor Migaya Ketch, who has proposed Amici.
Good morning, my ladies and my lords. I'm Barbara Kwanga. I appear for the proposed intended Amici, Professor Richard Albert and Professor Yaniv Rosnai, Professor Yaniv Rosnai, in a ruling in the AG's appeal.
Thank you. I think we have taken the quorum of all council and parties present. Directions, like I said, were given on filing the responses, which were filed. We also received 7 applications found in the 3 petitions. We received 4 applications for parties seeking to join as Amici curiae, found in petition number 12 of 2021. We received 1 application for recusal filed by some members of the court, found seeking for some members of the court to recuse themselves in petition number 12 of 2021 by Mr. 𝙏𝙗𝙧 𝗏𝙗𝙧. We also received 1 application for joinder as an interested party in petition number 12 by the Party of National Union or Unity. 1 application for consolidation of the petitions filed in petition number 11 of 2021 by Duncan Oburu Ojwanga. We deliberated on those applications as a court and considered the written submissions pursuant to Rule 4 and 31(1) of the Supreme Court rules, and the court will deliver our decision on those applications. On the application for recusal, I will request the Honorable Justice Philomena Mwilu, the Deputy Chief Justice and Vice President of the Court, to read the court's decision.
I'm most obliged, my Lord the Chief Justice. This is the application for the recusal of 2 of 3 judges of the court by Isaac Alocher, and this is the ruling of the court. Upon perusing the notice of motion application dated the 26th of October 2021 and filed on the 27th of October 2021 by Isaac Alocher, who is the 21st respondent in petition number 12/016 of 2021, seeking a recusal of Honorable Justices Mohamed Kadha Ibrahim, Smokin Wanjala, and Jokindongo Susana from hearing and determining the petition of appeals arising from the judgment of the Court of Appeal delivered on the 20th of August 2021 in Civil Appeal number E291 of 2021 as consolidated with Civil Appeal number E292 of 2021, E293 of 2021, and E294 of 2021. Upon reading the grounds on the face of the application, the applicant's supporting affidavit sworn on the 26th of October 2021, the written submissions by the applicant dated the 26th of October 2021, the affidavits and submissions filed on the 27th of October 2021 respectively, and in particular the grounds in support of the application, mainly that A, the applicant launched with the Judicial Service Commission a petition on 6th of April 2016 for the removal of 6 judges on account of a breach of the Code of Conduct prescribed for judges and for gross misconduct, which petition is still pending, the Judicial Service Commission being non-responsive, leading the applicant to institute petition number 301 of 2016, to which Isaac Aloch, Polo Alocher versus Hamed Isaac Hassan and 24 others, 2016 EKLR. B, the applicant's right to fair hearing under Article 50, Sub-Article 1 of the Constitution is non-derogable and has to be balanced with the right for other parties in arriving at a just conclusion, which right cannot be superseded by the doctrine of necessity and the duty to sit as enunciated by the court in the case of 𝙏𝙗𝙖𝙬 and 3 others, and in the case of 𝙏𝙗𝙬𝙧 and the Judicial Service Commission. C, it is in the interest of the administration of justice that the court be objective and impartial, pursuant to Article 73, Sub-Article 2B, and Article 166 2C of the Constitution, requiring each judge to observe the guiding principles of leadership and integrity, including objectivity and impartiality in decision making. And considering the grounds of opposition dated the 1st of November 2021, filed by Paul Mwangi and Company advocates on behalf of the 20th respondent, the Building Bridges to a United Kenya, National Secretariat of the BBI Secretariat, and Raila Amolo Odinga, the 23rd respondent. The said respondents oppose the application on inter alia the following grounds. A, the application is an afterthought. It is ill-conceived and intended to convolute and delay the hearing and determination of the petition. B, the applicant has not demonstrated and or adduced any such evidence in support of the allegations on bias by any of the cited judges. C, the application is self-defeating for the reason that whereas the applicant cites 3 judges for recusal, it seeks the recusal of only 2 of them. D, the application offends the doctrine of the duty of a judge to sit. And further, considering the applicant's further submissions dated and filed on the 3rd of November 2021, in which he proposes that pursuant to Article 159, Sub-Article 2C of the Constitution, the appeals instead be heard and determined by arbitration, conducted under the supervision of the court, the modalities of which can be dealt with during the case management conference. The court took the liberty to establish from the Judicial Service Commission the existence of the applicant's petition against the 3 judges. The Judicial Service Commission reports that it does not have evidence of ever having received any such petition, and there's nothing on its records. The 3 judges are similarly not aware of the existence of any such petition for their removal filed with the Judicial Service Commission by the applicant. In the above context, therefore, we make the following determination. A, the applicant has not adduced any evidence as to the nature and contents of his alleged petition to the Judicial Service Commission against the judges to enable the court determine the extent to which the applicant is aggrieved against each of the named judges. B, in the absence of the petition by the applicant against the judges before this court, either directly or through the Judicial Service Commission, the possibility of bias or impartiality we find is far-fetched and speculative. C, the applicant has not spelled out any specific allegation that is likely to impair the judges in dealing with the matter against the applicant, as the applicant indicates willingness to have either of the three judges he's accusing to be part of the bench and to have his petition resolved through alternative dispute resolution mechanism. D, the applicant having instituted his petition against the judges to the Judicial Service Commission, the same should be allowed to take its course, as the Judicial Service Commission is an independent constitutional body and operates separately from this court. Indeed, the applicant indicates that he took out proceedings in Isaac Aloch Polo Alocher versus Ahmed Isaac Hassan and 24 others, which proceedings we have not had sight of and in any event are not subject of our determination. E, Article 25 of the Constitution protects the right to fair trial under Article 52 of the Constitution, which only applies to accused persons in criminal proceedings. This is distinguishable from fair hearing alluded to by the applicant under Article 51 of the Constitution. F, the doctrine of necessity and duty to sit, as set out in the case of 𝙏𝙗𝙬 and that of 𝙏𝙗𝙬𝙧, and appreciated by the applicant, necessitates that the present matter must be heard on its merits. This is owing to its public interest nature. We note that none of the other parties in this matter has supported the present application, and as rightly noted by the 20th to the 23rd respondents, this court under Article 163(7) of the Constitution and Section 3 of the Supreme Court Act is mandated to make authoritative findings and settle points of law such as those raised in the appeal before the court. G, the issue as to whether the necessity and duty to sit amounts to derogation of the right to fair hearing under Article 50, Sub-Article 1 of the Constitution does not arise under these circumstances. H, the judges having been appointed in their present positions under the Constitution, including satisfying the provisions of Article 73(2)(b) and Article 166(2)(c) of the Constitution, their impartiality and integrity can only be negated following due process, which the petitioner alleges to have invoked, but which is inconclusive. 7, having found the foregoing determination, we make the following orders. 1, the notice of motion application dated the 26th of October 2021 lacks in merit and is hereby disallowed. 2, there shall be no orders as to costs. Orders accordingly. Thank you, Chief Justice.
Thank you very much, the Honorable Deputy Chief Justice, for reading that ruling decision of the court. I will now go to the application for the joinder of an interested party, and I will request the Honorable Lady Justice Joaquin Dongo, Supreme Court Judge, to read the court's decision.
The Honorable Chief Justice, Deputy Chief Justice, Justices of the Supreme Court, Council, this is the ruling of the court on the application by the Party of National Unity to be enjoined as interested party. I'll read it in summary. The full ruling will be available after this. Upon perusing the notice of motion, application dated 12th October by the applicant, Party of National Unity, and noting the applicant's filed submissions, also noting the opposition of the 7th, 8th, 9th, 13th, and 18th respondents, and considering all arguments and the law as set out in the Trusted Society of Human Rights Alliance and Mumo Matemo, and also in the case of Francis Muruatetu and others, we find that the applicant has not met the threshold for admission as an interested party, as it has failed to establish a personal interest or stake that is proximate enough to occasion any prejudice to it if not enjoined in these proceedings. We therefore find no merit in the application and we accordingly dismiss it. There shall be no order as to cause.
Thank you, Honorable the Justice Njoki Ndongo, for delivering that decision on behalf of the court. I will now request the Honorable Mr. Justice Renaura, Supreme Court Judge, to read the court's decision on the joinder of
petition number E016 of 2021. We have perused the affidavit in support, the submissions by the applicant, 23rd respondents. We have looked at the law in Rule 19 of the Supreme Court rules, the case of Trusted Society of Human Rights Alliance vs. Mumo Matemo, and Francis Muruatetu and another. We are not convinced by the arguments against the admission by the 20th and 23rd respondents. We see no evidence of bias, of lack of neutrality, and therefore, having considered the application against the rules and the law, we make the following orders. The motion dated 1st October 2021 and lodged on 4th October 2021 by the intended Amici curiae is allowed. And this is important. The Amici briefs attached to the application are deemed as filed, and the applicants shall not make oral submissions at the hearing of the petitions. Parties shall bear their own costs. The second ruling is on the application of Professor Migai Akech to be admitted as amicus curiae. We have looked at Rule 3, 19 to 31 and 50 of the rules, the practice directions of the court. We have considered the grounds in support of the application, the reliance on the case of Trusted Society of Human Rights Alliance vs. Mumo Matemo. There is no opposition to the application. Having considered it, we are also of the view that Professor Migai Akech, in his brief, will be of valuable assistance to the court, and we have seen that he has demonstrated expertise in his field relevant to the proceedings before the court. In the circumstances, the application dated 20th October 2021 and lodged on 22nd October 2021 by the intended amicus curiae is allowed. The amicus brief attached to the application is deemed as filed, and the applicant shall not at the hearing of the petitions. Parties shall bear their own costs. The third application, Professor Richard Albert and Professor Yaniv Rosnai, they have relied on the rules 3, 1 and 50 of the rules. We have considered the grounds on the face of the application. We have read the Amici briefs by both Professor Richard Albert and Yaniv Rosnai, their reliance on Francis Muruatetu and Trusted Society of Human Rights Alliance. We have looked at Rules 19 of the court rules and the two decisions I've just quoted above. We have seen that the applicants intend to address the court on the issue of constitutional amendments relevant including questions touching on the basic structure, its scope, relevance, and applicability. In the circumstances, we have the view that the applicant's very detailed amicus shall be useful to the court, and therefore we shall allow the application to be admitted as amici curiae. The amici briefs are deemed as filed, and the applicants shall not make oral submissions at the hearing of the petitions. Parties shall bear their own costs. The fourth and last application for admission as amici are by the by Professor Charles Fombad and Professor 𝙏𝙝𝙖𝙬. They have relied on Articles 1, 2, 3, 10, 48, 159, 160, 164, and 259 of the Constitution, and Rules 19, 1 and 2 of the Supreme Court Rules, as well as the affidavit sworn by Sally Omoto, advocate. We have looked at the amici briefs. They have detailed a number of questions for Professor Fombad. He has asked 3 questions that he wishes to address, and Professor 𝙏𝙗𝙬 has similarly raised 3 questions which he wishes to address. Having looked at the law rules, the cases of Raila Odinga and others versus IEBC, Trusted Society of Human Rights versus Muma Matemu, we are of the view that the admission of the amici curiae will be useful in achieving our mandate to develop the law with the assistance of input from parties appearing before us. And we find that the amici have filed a detailed brief which shall be of use to the court, and therefore we shall admit their application, we shall allow the application, admit them as amici curiae. The briefs attached to the application are deemed as filed, and the applicants shall not make oral submissions at the hearing of the petitions. Each party shall bear their own cost. Thank you, Honorable Chief Justice. Thank you, judges. Thank you, Council.
Thank you, my Lord, Justice Renaura, for delivering the 4 rulings on behalf of the court. I will now ask the Honorable Mr. Justice Ouko, Supreme Court Judge, to read the ruling on the application for consolidation.
Thank you, my Lady Chief Justice. It's a straightforward application. It's brought by way of notice of motion by Dr. Duncan Oburo Ojwang, Dr. John Osogo Ambani, Dr. Linda Musumba, who are seeking leave to consolidate petition numbers 11, 12, and 13 of 2021. Upon perusal of the affidavit of Duncan Oburo Ojwang, and upon perusal of the response by those parties who have filed their submissions in this application, which is essentially not opposed, and being guided by this court's decision in the case of Law Society of Kenya versus Center for Human Rights and Democracy and 12 others, and considering the provisions of Rule 12 of this court's rules, we have no doubt that the application meets the threshold for consolidation. We further find that petition number 12 of 2021, the Attorney General versus David Ndei and 73 others, encapsulates most of the key grounds common to the rest of the other petitions, in contrast with the appellant's petition number 11 of 2021, which raises a single issue. The order of proceeding of President's proceedings and presentation will be shortly given by the presiding Chief Justice, but we make the following orders in regard to this application. Number 1, that petition number 11 of 2021, Murara Amoke versus His Excellency Uhuru Muigai Kenyatta and 83 others, petition number 12 of 2021, the Attorney General versus David Ndei and 73 others, and petition number 13 of 2021, IEBC versus David 𝙏𝙗 and 81 others, are hereby consolidated. Petition number 12 of 2021, the Attorney General versus David 𝙏𝙗 and 73 others, will serve as the lead file in the proceedings, save to add that they will need to add all the parties that are omitted. For instance, Mr. Ochiel's clients, Dr. Mwimali and Muhuri, and any other that may have been omitted. Those are the orders of this court. Thank you, my lady CJ.
Thank you, my Lord Justice Obuko, for delivering the ruling on behalf of the court. Having delivered the 7 interlocutory rulings arising from the 7 interlocutory applications, the 3 petitions are now consolidated, and the lead file is petition number 12. We will now proceed to give directions for the hearing of the petitions as consolidated. In light of the above decisions, the directions of this court with regard to disposal of the consolidated petitions are that petition number 12 will be the lead file. The petitioners in the 3 respective petitions will be the appellants, while the rest will be the respondents. At our preliminary review of the record, we have been able to discern some issues which will guide counsel on the filing of the submissions, and I will request my brother, the Honorable Mr. Justice Ibrahim, to read those issues. I also wish to hand, if any party feels at liberty to hand another issue, they can do so.
Thank you, my Lord, the Honorable Chief Justice and President of the Court. The Court has considered, having read the record thoroughly, the issues raised in the petitions. 3 petitions were lodged in the Supreme Court challenging the judgment of the Court of Appeal in Civil Appeal number E291 of 2021 as consolidated with E292, E293 and E294 of 2021, delivered on 20th of August 2021. A summary of the issues raised in each petition is set out herein below. 1. The basic structure doctrine is whether the basic structure doctrine is applicable in Kenya. If so, the extent of its application, whether the basic structure of the Constitution can only be altered through the primary constituent power, and what constitutes as the primary constituent power. This emanates from the petition by the Attorney General. 2. Whether the President can initiate changes and or amendments to the Constitution, and whether a constitutional amendment can only be initiated by Parliament through a parliamentary initiative under Article 256 of the Constitution, or through